A trial in the Senzomeyiwa murder trial case has begun. This after the judge granted the state's request to lead evidence on the confession statements by the accused. The defense unsuccessfully tried to oppose the trial within the trial. The first witness, retired police officer Mhlanganyelwa Mboto, has since taken to the stand. On the alleged confession statement he extracted from suspect number one, legal expert Melusi Xulu is standing by to take us through what we have seen and heard throughout the course of the day. Thank you very much for your time this afternoon. Essentially, accused number 1 and 2 allegedly made confession statements, which their defense counsel disputes. Accused 3, 4, and 5 allegedly made warning statements, which their defense counsels say, well, they did not. I beg your pardon. 1 and 2's defense counsel says they made the statements under duress, rather. So let's just get a little bit of context in terms of what transpired earlier.
My Lord, irrespective of the fact that my client is very specific or not, the state says accused number 1 and 2 may pointing out the confessions. That does not exclude me from participating.
No, it doesn't, of course.
Yes.
It doesn't.
That is the reason why then I'm saying, my Lord, that any document that pertains to them as well.
Yes.
It needs to be conversed with us before it can be handed over to the court. The court cannot hand documents to the court before those documents are conversed with us.
But you see
that is my concern.
Yeah, but you see what this gentleman is saying, Mr. Baloyi. He says you have that pro forma form. That's what he says. It's not me.
I don't have that pro forma form, which part of which has been deleted before it was handed over to the court.
Yes, Mr. Baloyi.
We really need to save court time here. We've made it clear that as far as the first witness is concerned, that issue doesn't arise, and if Advocate Nisi can point us to a specific
Why don't you
point,
give Advocate Nisi the redacted part? You say you have redacted it.
Yes.
Just give him the document, which is you call the pro forma.
And it should not only be myself. And
no, please, I'm addressing your concerns. The other gentlemen can speak for themselves. And Mr. Ngumalo knows what to say.
That's exhibit HH, my lord, on page.
But give him the redacted part, your redacted part.
Yes.
Pro forma.
Yes, I just
because he says he doesn't have that one.
Yes.
In his possession.
Yes.
Actually, what you should do, give it to each and every counsel.
Melusi Xulu, that parts of the pro forma form were deleted by the state. Is that unusual?
Good afternoon to you and to the viewers at home. It's unusual because there must be transparency in how the documents are handled. And, like we discussed earlier, those are the things that should have been canvassed and dealt with at the pre-trial conference, pre-trial stage, to say there are certain documents that the state has given us and we don't have everything in full, it's redacted or it's not clear, and they could have been raised then, or they could have been raised during this week, because from Tuesday, all we knew was we were going to deal with the confessions, only to find that there were warning statements that were made by accused 3 to 5, but there are also some issues or statements that are redacted, but they say they've never made those statements. And what I see is if there are signatures there, this matter might have to be postponed for the handwriting aspect. So there's a lot that will, be dealt with from this point. But for now, obviously, we're going to deal with the confessions made by accused 1 and accused number 2.
Let's deal with the confessions or the alleged confessions made by accused number 1 and number 2. Their lawyers say that it was made under duress. And then you have the witness that has taken to the stand, retired Colonel Mhlanganyelwa Mboto, who says the statements or the alleged confession statement from accused number 1 at least go as far as containing his fingerprints and his signature, because everything was done according to the law. He was arrested on the 30th of May 2020 and he made the confession statement on the same day of the 30th of May 2020. He was not assaulted. The only injuries that were visible were because of the handcuffs that were too tight that were put on him, but he was not under duress to make the statement, and he signed to say so.
Yes, I think the judge did read Section 217 of the Criminal Procedure Act into record. And it says three things. One, if you're going to make a confession, you must make it, freely and voluntarily in your sound and sober senses, and you must not be unduly influenced by anybody to make the statement or to make the confession. By definition, a confession is an acknowledgement of guilt, unequivocally so, and it's akin to a plea of guilty in court. That is why it's so essential that if you're going to make a confession, at least according to Section 35, you must have your attorney there, and you must be warned that if you make this confession, it's going to be used as evidence in court. So you cannot be compelled to make a self-incriminating evidence or statement or confession. So that is the right that you have as an accused. But what is clear is that for now, Colonel Mboto says he warned him of all of that. It will be tested though whether he really did give him enough explanation about the consequences of making it or of making the confession as he did. Now, here's what is interesting for me. I hope the defense, especially for accused 1 and 2, they've got this in order. As much as it's unrelated, but if you look at everything that matters, there is a Netflix documentary about this case. Moses' father, accused number 1's father, he says he was brought to Nongoma to see him, and he was assaulted and strangled, and he said he was told to make this confession, and he was going to be given 100,000, and he was told to link accused number 3 to 5. So I don't know whether the defense will be able to use that or use accused number 1 as a witness. So there are those things too. The critical question here, just before I end, is was the statement made freely and voluntarily in the sober sense, and was he not unduly influenced? So we've got to discover that as our trial in a trial proceeds.
Is it clear to you when asked what are you arrested for? It is alleged that he said arrested for shooting a person. Which person?
That is why the court said, look, that admission will not be taken as evidence because he was not one. The critical aspects of Section 35, we're coming back, or we're coming from a history of apartheid where people were just arrested without their rights being known or being explained. So Section 35 is critical in the sense that before you utter anything, you are told that what you're going to talk about or what you're going to confess is actually something that you must not do if it's going to be used in trials. So the court said, look, shooting, if you say you shot someone, you're not going to use that. And obviously, Advocate Baloy acknowledged that as well. But the critical part then will be the confession, which is what I'm more interested in. And as the case is proceeding till next week, we will see how the defense will challenge the confession that was made.
Because he was arrested on the 30th of May, 2020. He made the confession statement allegedly on the 20th of May, on the same day, rather, in 2020 at midnight. So is it 2020, 30 May, that's when he was arrested. 2020, 30 May at midnight, that's when he allegedly made this confession statement. Is it unusual that you arrest a suspect and on the same day, because he says he was arrested, he doesn't remember the time, but it's in the afternoon. Is it unusual that on the same day you arrest somebody and on the same day you get a confession statement?
It's not usual. That is why, I mean, if they say you have a right to a legal representative, and he says, I have Mr. Nkona, once he mentions Mr. Nkona, I mean, this is a lay person. Once they mention that there is a Mr. Nkona that I have, I think at that point the police should have rather contacted Mr. Nkona and have him present during the confession, because the danger of not having a legal practitioner when making a confession or admission is that it's possible that from a constitutional perspective, that particular confession will not be allowed for constitutional purposes, because you have a right to have your legal representative whilst you're making any confession. So that is why I'm saying at least maybe once they've heard that there is a Mr. Nkuna, they should have got his number, call him and say, we have a client here and we'd like to make a confession. Can you come and be present? And maybe we'll make it tomorrow from 8 o'clock in the morning. Then at least he might have had enough time to think properly whether he's making a confession or not. And remember, there is evidence that he was assaulted. His father has stated that he was assaulted and strangled, and he was promised 100,000 rand. So I think I'm not putting a cart before the horse right now, but I think there is, a way to challenge this confession, but it will depend how the defense strategizes to the challenge.
Okay, because the witness alleges that the accused number one, said he did not need a lawyer to make a statement, and Mboto claimed that accused number one was warned in terms of Section 35 of the Constitution. But also today there was a standoff between the judge and Advocate Melusi on behalf of accused number 3. Let's revisit that moment.
That is the concern that I have, that as we will be embarking upon this process of a trial within the trial, we want to know exactly the case that we are going to be facing as it will be put forward by the state, whether we'll be looking at the statement that amounts to admission or what. We cannot just get into a trial within a trial without knowing exactly what is it that the state wants to allege against us.
I don't know what...
No,
Mr. Melusi, please. Mr. Melusi, please. The state advises the court that your clients have made a statement.
Yes.
All of you. 2, 3, 4. Even 1 and 2.
Yes.
And you are saying no statements were made.
Yes.
Fine. That will transpire and when the evidence is being led by the state, whether there is a statement or there is no statement.
Thank you, ma'am.
Fine. But this court has made a ruling that a trial within a trial should be established and to be held after this court has made inquiries. Not a court which just out of the blue said, hey, trial within a trial. I've made inquiries. And these inquiries, in terms of the law, satisfy the need for the establishment of a trial within a trial.
What is this trial within a trial? What does that mean that got the defense hot under the collar? Because at some point the judge had to tell him to sit down, and he went as far as saying he's in charge of this court and no one, not a single person in this room will tell him how to conduct this trial.
Well, look, the trial within a trial, it just deals with certain aspects of evidence, like maybe if you made an admission or a confession, or during when you were arrested, you made a warning statement and you did make some certain admissions. So if you are saying you did not make those admissions or you made them under undue influence, obviously, then the state has to prove that, in fact, you made them without any undue influence. So there are two issues here, the way I'm saying it. On Tuesday, we slept knowing that on Friday we're going to deal with confessions. So Advocate Melusi is saying also that it is stated that, or the prosecution is stating that they will also provide evidence that accused 3 to 5 made statements whilst they were being arrested. So now he's saying, look, we don't have those statements, and our clients are saying they did not make those statements. So the trial within a trial also has to be done for accused number 3 to 5. So the judge is saying, no, we're going to start now because we're prepared to start now. I think the way to deal with this is that maybe to avoid wasting time, they deal with the confession parts, which is accused number 1 and 2. And whilst they're doing that, maybe after today's postponement, they will be able then to get their statements which apply to their clients, accused 3 to 5. Then they'll prepare so that the matter proceeds. But maybe the way it was handled, how the decision was made, the judge just wanted to stamp authority to say, no, we're starting now, because obviously this was prepared from Tuesday or Wednesday, if I'm not mistaken. So I think that is what was happening. But maybe if I would, put my opinion on this, I think the defense and the state, maybe they have to have their own discussions before they start whatever they're doing, if there are some confusion, so that when they come to court, they've already made agreements how they proceed, because sometimes it's as if they have to come and deliberate whilst the matter has to start, and it delays issues. It's better if they discuss things and they say, my lord, this is what we've discussed and this is what we disagree on. Then, the trial will happen fast, or rather, a trial within a trial at this stage.
All right. Thank you very much for your time this afternoon, Melusi Xulu, a legal analyst.